So this video is about access to justice and funding of legal matters. So from your own knowledge, I'd like you to have a think about the following questions before we get started. So why might somebody need to get legal advice? And how can you usually pay for that legal advice? So Mr. Justice Darling said that the law courts are open to any man, so are the doors of the Ritz Hotel. So what do you think he meant by this? So what he's saying is that the Ritz Hotel, very expensive, very posh, is open to anybody, but importantly, it's open to anybody who can pay in the same way that the courts are. And this is a bit of an issue in that justice shouldn't be available just to those who've got the money to pay for it, but to everybody who has a legitimate legal case. So a brief history of legal aid in the UK. So in 1949 we have the first state-funded legal aid scheme. Then in the 1980s the system developed into 6 different schemes, and the Legal Aid Board administered those schemes. And the cost of the systems kept escalating and escalating. In 1999 we had the Access to Justice Act, which made some major changes. And then in 2012 we have the Legal Aid Sentencing and Punishment of Offenders Act, which introduced further cuts to legal aid. So between the end of the 1940s to 2012, and remember in legal terms 2012 is yesterday, we have at the end of the 1940s the system becomes available, state funding is available for people. It then becomes very, very complicated in the 1980s, and then coming towards today, we've simplified but also slimmed down who legal aid is available to. So looking at the Access to Justice Act 1999, there are key changes brought in by this Act. So the Legal Aid Board that we talked about a moment ago has been replaced with the Legal Services Commission. Community legal services partnerships are developed, and it introduced a quality mark. So you had to be giving certain standards of legal provision in order to get that quality mark, and if you didn't, then you weren't able to do legally aided work, and you weren't able to be paid as a lawyer like that. And 6 individual schemes were replaced with 2 new schemes: the Community Legal Service for civil matters and the Criminal Defence Service for criminal matters. So legal aid today, Legal Aid Sentencing and Punishment of Offenders Act 2012, LASPO as it's more easily known as, has dramatically reduced the availability of civil legal aid, and criminal legal aid has also been reduced somewhat. Legal aid is now administered by the Legal Aid Agency, who is in turn controlled by the Ministry of Justice. So some things to think about. So what is legal aid? So make sure that you pause the video and have a think about those. So what is legal aid? And for what reasons do you think someone would fail to get the legal help that they need? This is a tricky question. So what matters do you think legal aid is available for? So what I'd like you to do is, if you have the Joseph Chamberlain booklet, you can complete it in there. If you don't, you can create a table similar to the one that you see on the screen. So you're going to have a listen and fill in the information as we go along. So if you need to, pause the video here to make the table. If not, you can carry on with me. So starting with civil legal aid. LASPO states civil legal aid is only available where the subject area is listed in Schedule 1. This concerns cases primarily that are directly concerned with an individual's human rights. And civil legal aid is not available any longer for medical negligence, so those are the things that it's not available for. What you can see on the screen is the things that they are now available for. So it's been retained for environmental law, asylum, clinical negligence cases where the negligence occurred in the first few weeks of life, mental health and child welfare, and judicial review. In addition to reducing the number of issues that civil legal aid is available for, the means test, which tests how much money you've got, has been reduced for civil legal aid, has been tightened. But civil legal advice is a national telephone service and a website that provides free legal advice on civil matters. So although it's been restricted significantly, we now have this phone line which can provide some assistance. So what I would like you to do is pause the video here and then brainstorm everything that you can remember about civil legal aid in order to answer the question below. Explain government funding of civil cases, and you'll need to rewind the video, watch back the key parts so that you can check your answer. So now we're going to move on to criminal funding. So just like before, Joseph Chamberlain people, you've got the section in your booklet. Everybody else, if you can take a copy of the table that you can see on the right hand side, and you'll be filling that in a moment. So criminal legal aid is still given on a demand-led basis, so there's no set budget, unlike civil legal aid where there is a finite amount of money available. Criminal legal aid, there's no set budget, and all cases that fit the merits and means test criteria will be funded. The legal aid agency funds directly the provision of criminal legal services, and it employs public defenders and pays duty solicitor schemes. Therefore, criminal legal services are provided by both public and private lawyers. Contracts for legal aid, there are two different types of contract types. So if you are a solicitor, you can do criminal legal aid work if you have a contract to do so. And there are two different types. So there's a set number of duty solicitor providers, contracts awarded in each geographical area, and you have to put in an application known as tender, and if you meet certain criteria, then you will be awarded one of these contracts. There is also an unlimited number of own client work contracts to any provider who satisfies the requirements. So let's have a look at the means test. So as I said before, a means test is testing how much money you have or probably haven't got. And the Criminal Defence Service Act 2006 reintroduced the means test for criminal cases in the Magistrates' Court. The Crown Court had the means test reintroduced in 2010. So both Crown and Magistrates cases have got a means test. LASPO introduced a further financial eligibility threshold in the Crown Court, and this will again restrict those who are eligible for legal aid. If the defendant is acquitted, their contributions will be refunded. So if you are found not guilty, then you'll get the money back. But if you're found guilty, then any contributions that you may have made because you have a certain income, you have a certain amount of money in the bank, you will lose those if you are found guilty. Public defenders. The legal aid agency employs a number of criminal defence lawyers who are known as public defenders, and there are a limited number of these, and there's no plans to expand the scheme. So for the most part, solicitors who do criminally legal aided work also work for a law firm. Criminal Defence Direct is a telephone service which was set up in 2005. and it provides free telephone advice to people detained by the police but on non-imprisonable offences, so that they don't have to have somebody come out and give them in-person legal advice. So what you can hopefully see is where legal aid has been restricted both for civil and criminal matters, the way that the government have tried to counteract this is by creating telephone advice lines. Some would say that this bridges the gap for very minor things where people are more looking for reassurance. However, this isn't always going to solve the problem, and it does mean that there are going to be some people who would have got legal aid who now all they have available to them is a telephone service. So, leading on from what I've just said, I want you to think about what's the most significant problem with civil legal aid and what's the most significant problem with criminal legal aid. So, problems with legal aid system in general: access to justice is often denied. There are problems with the public defender scheme in that it's no longer growing and public defenders who quit aren't being replaced. There's the cost of criminal cases. Some are very, very expensive, and it's an unfair trial potentially if legal aid is refused. And there's too heavy a reliance on private practice. So in your opinion, which is the most significant problem with the funding of criminal cases, and can you give your reasons? And can you suggest a way to fix the problem that you've identified? So we've had a look at civil legal aid and we've had a look at criminal legal aid, and you should now be able to answer both of these 6-mark questions. In the exam you would have 8 minutes to answer explain public funding of criminal cases and then explain public funding of civil cases. So now we're going to move on and have a look at some other ways that you could fund a legal matter. So you could use your own private resources. So funding through your income, savings, or bank loans. So what are the advantages and disadvantages? So another way of privately funding a matter is through insurance. There are 2 types of insurance for legal matters: before the event insurance and after the event insurance. Before the event insurance is usually included in insurance policies. So maybe it's a household policy, maybe it's your car insurance policy is a before the event policy. And after the event is likely to be a standalone policy, which is more expensive after the thing for which you require legal advice has taken place. Another way of funding a matter yourself is a conditional fee arrangement. And these are covered under the Courts and So let's have a look at one of these in practice. So in the case of Coventry and Lawrence from 2014, a homeowner won a claim for insurance against a small business operating a noisy speedway track near their home. The claim was only worth £74,000, but the cost order This is also seen in Motto case. This is the biggest cost case in legal history. Lawyers brought a claim on behalf of 30,000 African people who suffered ill health when a contractor illegally dumped toxic waste in the sea near to where they lived. They won the case and were awarded £30 million, which meant £1,000 compensation for each person. And the lawyers working under a conditional fee arrangement charged a 100% success fee, and that took the bill to over £100 million. The defendants were able to challenge this, and the bill was reduced by 40%. So huge figures arise from this. So that was the old situation with conditional fee arrangements, no win, no fee. This has all changed under LASPO 2012. So since LASPO, the success fee for conditional fee arrangements is no longer recoverable from the losing party, except for privacy, defamation and insolvency claims. The client now has to pay the uplift fee themselves, even if they win their case. And for personal injury cases, the success fee is now capped at 25%. For all other cases, the success fee can be 100% of the lawyer's usual fee, so they get the fee that they would have charged. The result is that conditional fee arrangements will probably be used. And contingency fee arrangements. Under a contingency fee agreement, lawyers receive a share of the successful claimant's award of damages. Contingency fee comes from the fact that the payment of the lawyer is contingent on the claim being successful and damages being awarded. So before 2012, contingency fees were unlawful. LASPO now allows lawyers to enter into contingency fee agreements known as damages-based agreements with their client. The lawyers are allowed to receive up to 25% of the damages for personal injury cases, 35% for employment cases, and 50% for all other cases. If the defendant loses, they pay the claimant's costs. If the claimant loses, so some advantages of contingency fee agreements. So there's no cost to the state, so this isn't going to raise your taxes. It widens the access to justice, and it encourages lawyers to perform better as they have a financial interest in being successful. But disadvantages: there's a lower take-up rate, and they're not popular with lawyers. No win, no fee in reality means no win, pay anyway. Lawyers are too heavily involved in the financial outcome, and they can be risky, uncertain that cases will not be taken on.